Utah could become another state to pass a state version of a Religious Freedom Restoration Act.
So if we are stepping on someone's proverbial toes religiously, we want a pretty high standard there in the law to protect those religious liberties and interests.
We talk with the sponsor of a new bill here in Utah that would strengthen religious freedom protections, and we address criticisms, equipping you to be a better champion of religious freedom. You're listening to Defending Ideas. Defending Ideas is a weekly podcast produced by Sutherland Institute. On this show, we are committed to renewing the principles of common sense conservatism, making you a better champion of sound ideas. Welcome back to another episode of Defending Ideas. I'm your host, Nic Dunn, and this week we're talking about religious freedom, where it stands today, and what might be some policy interventions to help strengthen religious freedom moving forward. And we're joined by Senator Todd Weiler, who represents District 8 in the Utah State Senate. Senator, thanks so much for joining us on Defending Ideas.
Thanks, Nick. Great to be here.
It's great to have you and talk about an issue that's a topic that Sutherland works on a lot, which is religious freedom. And I want to start off by asking you, you are the sponsor of Senate Bill 150, Exercise of Religion Amendments,
yes,
before the Utah State Senate. I want to ask you first, just tell our listeners, what is the bill and what does it do?
Yeah, Senate Bill 50 would allow Utah to follow the pattern that Congress set in the Religious Freedom Restoration Act, which is commonly known as RFRA or RFRA. The federal statute, which was passed in the early 90s, reflected widespread outrage over the Supreme Court's decision in a case called Employment Division versus Smith in 1990. And there, the Supreme Court read the First Amendment to mean that the promise of the free exercise of religion was actually meaningless when the law harms religious freedom incidentally. So RFRA protects through statute what the Smith decision took away under the Constitution. And essentially, the statute requires the government to satisfy what we call a compelling interest standard, which is a high legal standard. It's the highest legal standard in constitutional law whenever a law genuinely burdens religious exercise. So RFRA became the law federally in 1993. It passed the House of Representatives, Congress, unanimously, and only 3 senators in the Senate opposed it. And a few years later, the Supreme Court ruled again in the case of the city of Bourne versus Flores in 1997, and they concluded that RFRA only applies to federal laws. And so since then, we've had 25 states, including Idaho and Arizona, pass what we call mini RFRA laws, but Utah hasn't. And so, I learned, recently that, that Utah was kind of an outlier in that sense. And, we hold religious freedom as a culture in Utah, very close to our hearts. And so I wanted to change that and make, Utah one of the many RFRA states.
So when you said that there was that ruling that said that the RFRA on the federal level only applied to federal laws, does that mean that a state could pass a law that would constrict religious freedom in some way that if it were a federal law would be in violation of RFRA, but because it's a state law is not? And that's what then these state level religious freedom restoration acts are intended to stop? Am I getting that correct?
Well, yeah, and I think there's always a concern that what happens if Congress repeals the federal RFRA as well, because it is an unusual decision, I think, that the Supreme Court in 97 would say that only applies to federal laws. So it's been 30 years, so I think it's a belt and suspender approach to a certain extent. If the federal law gets repealed, we'd have the state laws. And also, because the Supreme Court said it only applies to the federal laws, then it would apply to the state laws as well.
So what does it actually mean in practice? And thinking for our listeners who might just wonder, okay, well, do we need more religious protection, religious freedom protection in Utah, meaning that no one's stopping me from going to church, no one's kicking in my door telling me I can't pray? Aren't we good? Do we need more protections? Help our listeners understand where laws like this can help fill a gap that maybe is needed from a religious freedom protection standpoint. Okay.
Well, the current language of my bill kind of tracks what Arizona did in their mini RFRA. But the hope is that the state RFRA, the mini RFRA in Utah, would act as a shield whenever a state or local government enforced a law or a regulation that burdens religious practice. Under this bill, the government must show that it's pursuing a compelling interest through the least restrictive means possible. The test is what we call a factually sensitive test. I should say to your listeners, I am a lawyer. The government can still carry out its vital functions, even if the religious practice is affected unintentionally. But like RFRA, these amendments include definitions for key terms as well as technical provisions clarifying how the law would apply. So Senate Bill 150, if it's passed and enacted, it would offer judicial relief to a person whose exercise of religion is burdened by a government office or official that falls short of meeting the compelling interest standard in the law. And so we live in a world, Nick, that is becoming increasingly hostile to religion. And so we want to, have these protections in place just to make sure that, I think it's unlikely right now that the government would burden religion in Utah. But this protects all religion. It protects, not just Christians, but Muslims and Buddhists and all of the religions that we have in the world or in the state in particular.
One question I think could come up in the minds of our listeners is, how is this different from the Utah Compromise from a few years back? We got national attention for that, that was focused on anti-discrimination laws and balancing that with the religious freedom protections. What does this add that discussion or that compromise didn't? I guess help kind of put these two things in context for our listeners to understand how this is, I guess, complementary perhaps to religious freedom protections.
Yeah, I think that's a question a lot of people are asking themselves. So with the compromise, and I voted for that, I think that was in 2015, we tried to balance LGBT rights with religious rights. And so if, let's just take, you're at lunch at your workplace, okay? Most workplaces have like a kitchen or a break room. And so if you're sitting in there and, someone says, oh, I went to the gay pride parade yesterday. The compromise says, oh, we can't discriminate or fire someone because either they're gay or because they're going to the gay pride parade as well. Or let's say someone across from them in a different conversation or in the same conversation say, oh, that's interesting. I went to my ward party last night, and indicating that maybe they're a member of the Church of Jesus Christ of Latter-day Saints. So one of the many goals that we were trying to achieve with that is you can discuss these things in the workplace without fearing discrimination. Now, if you're Nick, if you were the boss and you hired someone and you said, hey, if you don't get baptized in my church, I'm going to fire you, that wouldn't be protected. But just merely saying, oh, my son is getting married in the temple next week, that would not subject you, that you would be protected for that type of speech. And so we were trying to balance those interests in a way. We also gave some exemptions to BYU for their student housing. We found when we were doing that bill that BYU was probably exposed in some areas because they don't let men and women live under the same roof in most situations and things like that. And had they been sued before our compromise, they probably would have lost. But we gave them some special protections in there. So it was balancing those LGBT rights with religious liberties. This one is a little bit different. So if in a future pandemic, if the state of Utah says you can't go to church anymore, and somebody sued, then this would set a pretty high bar for the government to jump over to say that people can't exercise their religion.
So do you view this as an important broadening and deepening of religious freedom in Utah that is designed to be forward-looking, that in the future, if there were issues that came up, this would be an important resource as a law that would inform or I guess frame and direct to some extent what those legal questions would be that might come up in the future? I
think it's more of enacting fence posts. And so these questions really only arise when there's a lawsuit, quite frankly. But we're trying to set a standard, set the bar high so that if the government does impose on someone's religion that and they challenge it, that they're going to have to jump pretty high. So for instance, if I'm going to give an unlikely example, but if the government said you can only renew your driver's license on Saturdays, and the Seventh-day Adventists and the Jews said, hey, Saturdays aren't good for us, that's our sacred day, and the government said, too bad, you're going to have to break your Sabbath if you want to renew your driver's license. That's something that probably wouldn't withstand scrutiny under this legal standard that we're establishing here.
What pushback have you received on this bill, or is there pushback you've seen on similar bills or this issue in general, maybe in other states? And what's a good response to those criticisms?
Well, this was in committee recently, and we heard testimony from the ACLU, and they have traditionally opposed RFRA on the national and the state level. It's interesting. I'm old enough to remember when the ACLU really stood up for the First Amendment, but it seems to me, this is my opinion, that they stand up for their brand of the First Amendment and not for anybody else's. But that's changed over my lifetime. And we also heard from the Equality Utah on behalf of LGBTs. They're concerned that maybe an unintended consequence of this bill would somehow undermine the compromise that you mentioned earlier. And I'm trying to work through that with them and maybe get some language in there to clarify. That's not the goal. That's not my goal. I don't think that's anyone's goal. And quite frankly, I'm hearing a lot of worst case scenarios of things that have not, frankly, manifested in the other 25 states that have passed this law or similar laws.
So as we think about, for our listeners out there who might be thinking, well, I want to support religious freedom. I want to articulate the importance of, in this case, maybe broader or deeper protections for religious freedom in Utah. What are some key talking points they can use if they're talking with somebody who's a little skeptical of RFRAs in general, or maybe who isn't convinced that we need more religious freedom protections in Utah? What are some good talking points for those listeners so that they can go out and be better equipped to respectfully persuade folks in the middle who might be persuadable, even maybe folks on the other side who have a different view? What's the best way to talk about it and advance this principle? Well,
in my opinion, the best way is to understand that the federal RFRA that we got in 1993 was only necessary because the Supreme Court read the First Amendment in a peculiar way to say that the exercise of free religion was meaningless when the law harms religious freedom by accident or that wasn't the intent of it. So because Congress perceived that the U.S. Supreme Court had just taken away some of our religious rights, they wanted to restore them by statute. But then 4 years later, the Supreme Court comes back and says, hey, we like this RFRA statute, but it only applies to state law. And so the fear is the federal law. I'm sorry. So the fear is if a state court made a similar decision as the Employment Division versus Smith, we wouldn't have anything to protect us on state laws. And so it's a little bit belt and suspenders, and it's a little bit proactive. But I also think it's a way of just saying, look at this RFRA is not just for Catholics or evangelicals or for Mormons, if you will. It's for all religious beliefs. And I will tell you, as a member of the Utah legislature, and I've been up there for over a decade now, sometimes our laws do have unintended consequences. And so if we are stepping on someone's proverbial toes religiously, we want a pretty high standard there in the law to protect those religious liberties and interests.
How do you see this bill moving forward? Obviously, it's still in the process. Any predictions for us? Obviously, you're the sponsor, so I'm sure you're optimistic. But what can we expect to see as this debate shakes out in the coming days and weeks in the session?
Well, I think there might be some further tweaks and amendments. I try to be very collaborative in my approach to legislation. I don't want the LGBT community, I don't want the ACLU community to feel like they're being attacked or somehow we're trying to undermine their interests or undermine advancements that they feel like they've made in Utah, because that's not the goal of the bill. And just like I hope everyone will be respectful of other people's rights, I hope people will be respectful of my religious rights as well. And so this just kind of puts up those guardrails. And so the courts, when these challenges are brought to the judges, they kind of have the tools that they need to sufficiently address them.
Well, for our listeners, we will include the link to the bill text itself in the show notes, and it's Senate Bill 150, Exercise of Religion Amendments, so folks can go read it for themselves and, of course, follow along with the debate as it progresses through the session. And State Senator Todd Weiler, thanks so much for being with us on Defending Ideas.
Thank you, Nick.
We're going to take a quick break. We'll come back with more on this issue in just a minute. This is Defending Ideas. Stick around.
Sutherland Institute is an independent, nonprofit public policy think tank based in Salt Lake City, Utah. Our mission is to defend the principles of the American founding and strengthen the institutions of civil society essential for those principles to endure. Sutherland provides research, events, and multimedia to policymakers and the public to promote the principles of faith, family, freedom, opportunity, and responsibility. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. I'm Nic Dunn, and we're going to continue the conversation about the Religious Freedom Restoration Act that's being proposed here in Utah, where it fits with what other states have done and the context of the federal law that's the environment in which these debates are happening. But first, I want to mention, if you like what you're hearing today, please visit defendingideas.org. You can subscribe to this podcast on any of the major platforms and access those platforms from defendingideas.org. Apple, Google, Spotify, wherever you like to get your shows, just search for Defending Ideas and click that subscribe button. You can also find short clips from this episode and previous discussions that you can use in your conversations with friends and family about these ideas and that you can share on social media. You can access all of that at defendingideas.org. I'm joined now by Bill Duncan, who's our Constitutional Law and Religious Freedom Fellow here at Sutherland Institute, to continue the conversation and add some context of this issue of religious freedom protection. Bill, welcome back, and thanks for being with us.
Thanks for having me.
So, Bill, we heard from Senator Weiler about the bill he's sponsoring, Senate Bill 150, Exercise of Religion Amendments. But I wanted to bring you into the conversation to expand the context a little bit. And first, just to help make sure it's clear for our listeners, what is a Religious Freedom Restoration Act? Utah's not the only one. There's a lot. So first, what is a Religious Freedom Restoration Act?
Well, it's a law that says that when a government puts a burden on a person's ability to practice their religious beliefs, that the government has to show it has a really overwhelming reason to create that burden, and that it's doing so in the narrowest possible way. So as much religious practice is allowed as possible, only where something that a believer does that's actually harmful to others will be limited. And so it's a good protection of religious freedom in that way.
Give us some context for this, because those who have been following this bill in the legislative session, Senator Weiler, when he testified in favor of this bill that he's sponsoring, he mentioned that, look, there's a federal law that already does this. There's a number of other states that have been passing these. Give us that context, kind of help us understand where this concept started at the federal level, just so we know the environment in which this discussion is happening.
Yeah, it's a great question because it actually goes back even further than the federal law. So in the early 1960s, the U.S. Supreme Court interpreted the First Amendment of the U.S. Constitution, its protection of religious freedom, in exactly this way. And they are the ones who came up with that rule. When the government creates a burden on religious freedom, they have to justify that burden by an overwhelming, the term they use is compelling state interest. And they have to make sure that whatever limits they potentially may put on religion are as narrow as possible. That's the ruling the Supreme Court made in a case involving someone who didn't want to work on Saturdays and was fired as a result. So that had been the rule for a number of decades. In the early 1990s, though, the U.S. Supreme Court walked back from that. A majority of the court said, well, that maybe is more than the Constitution requires, and limited the protection that was given to religious exercise. Well, bipartisan majorities, super majorities, only 3 people in both houses of Congress voted against, decided they wanted to restore the standard that had been in place for a couple of decades, and to say when the federal government creates a burden on someone's religious exercise, this is the only way it can be justified.
I want to pinpoint one thing, because it's something you've talked a lot about before with events we've done here at Sutherland and in partnership with other folks. But those of us who are concerned about religious freedom and want it to be protected, this seems to be an example of we shouldn't rely on only the courts to do so. Because if at first, in the 60s, the Supreme Court was correct, so to speak, on religious freedom, but then things changed, does this point to the need in general for legislative approaches to religious freedom are actually really crucial for reasons like this?
That's exactly right. There's really 2 things that I think, maybe even 3, the 2 things at least that are really beneficial about this. The first is what you described. The court decisions can go one way or the other, but all branches of government have a responsibility to enforce the Constitution and protect rights. And so we ought to, we the people who are represented by legislators ought to make sure that happens. Another benefit is that we can't always predict the kinds of ways in which government might impact the religious practice of someone else. I may be very familiar with my own beliefs and kind of what's required of me and think, well, I feel like I'm basically protected. But that doesn't mean my neighbor whose beliefs are a little different than mine, whose practices are a little different, might not find that something government does, even unintentionally, can create some tension on their ability to act on their beliefs. And so we want to ensure that in those cases, when again, usually inadvertently, the government does something that may create a burden for someone's belief, that those are also protected. The reality is that ideally, we guess what these conflicts are before they happen. We pass laws that prevent them, and everything's great. The problem is if we don't do that, then often even if the person is successful in arguing that the First Amendment or the Utah Constitution protects their religious belief, it can take years and, of course, lots of money to go through litigation. So acting affirmatively to specify, here's exactly what's required of governments, here's how they ought to try and avoid these conflicts, that's really the ideal. And I think this type of bill does exactly that.
It reminds me of some other things that we've worked on. I think it was just last session, the 2023 session, a bill passed that gave some protections for students. So when they participate in sports activities, it essentially gave them some protections to still wear various religious clothing. And I think it was broader than just that. But is this an example of, we could go through piece by piece and try and identify specific things that need protecting and then craft laws for those things? But does a Religious Freedom Restoration Act kind of act like a blanket of protection, that it's much more broad? Is that fair?
Exactly. It catches any other kind of thing that might not be obvious. We've talked about this before, but imagine if a county is trying to create some kind of sewage regulations. It seems like the kind of thing, how would that impact religious freedom? Well, for most people, it won't. But for a small minority of Amish people, it might create. So we just want to make sure that there's always a backstop to ensure that everybody is protected to the degree we can. And I think that's why this has been valuable. The reason that Utah is maybe interested in this is because the federal Religious Freedom Restoration Act from the early 90s only applies to federal government actions. And so states, counties, cities, as they do things, those are not covered by the Religious Freedom Restoration Act. So this would clarify that same rule that is granted to protect believers nationally would also be granted to believers here in Utah.
And there's been a wave of other states doing this on the state level as well, right?
Right. Depending on who you ask, there are 24 or 25 states that already have these laws. And so Utah would just be another one.
So can you give any other examples? You mentioned a couple, but the kinds of things that are not protected today that would be protected if Utah passed and if it were signed a Religious Freedom Restoration Act. Any other examples that come to mind of specific protections that essentially we would gain?
Sure. Well, some of the initial decision by the U.S. Supreme Court came in the context of a person who was fired from their job because they were unwilling to work on a day they considered the Sabbath day. And that kind of protection, there's nothing in Utah law that specifically addresses that kind of question. And so if a person were to say, I know that my employer or the government could accommodate me in that kind of request, and they should, and it doesn't, again, create harm to others, then that would be protected. The situations like you described with the students where they or others who want to wear a religious emblem or something that's required by their religious beliefs, but might otherwise run up against a uniform policy or something. They require the government to accommodate them. If there are like housing or zoning regulations that might, imagine a church and gets redesignated in a zoning area, and they want to run a soup kitchen, or they want to preserve the way the church has always looked, and someone says, we ought to, knock that down. Those kinds of things would be protected by a law like this.
Is it fair to say that one of the reasons this is needed is, again, we could go through and try to predict every minute religious freedom protection that would be worthy of the law. But as you articulated earlier, there are a lot of religious practices that I may have no idea are an actual religious belief or practice. You may not even know, even as an expert in the field. So is this a way of saying, look, we cannot foresee the future. We can't predict everything. So let's create a law that basically says, as a baseline, the state is limited from infringing on things that are religious beliefs, religious expressions, and then that becomes sort of a guidepost for when these conflicts or questions inevitably come up.
Correct. And ideally, it's even better in the sense that the legislature itself, knowing that this is on the books, will be careful to notice, we want to do this. We think we have a good reason for it, but is this going to impact anybody else? And think ahead and say, okay, well, maybe we still need to go ahead to protect public safety or something. We may still go ahead with that regulation, but to think about that first to avoid as many conflicts as possible.
I want to ask you a similar question I asked to Senator Weiler in the previous segment, but where do you see this fitting in with the Utah Compromise? Again, the legislation that Utah got a lot of national attention for, balancing anti-discrimination protections with some religious freedom protections, and you had sort of groups on all sides of that issue coming together saying, yes, this is a good consensus. So what does a Utah Religious Freedom Restoration Act law do that the Utah Compromise didn't? And does this essentially build on that in a constructive way?
Well, I like to think that it does, in the sense that the compromise legislation, or I guess I know some people are uncomfortable with the idea of compromise, but the legislation on anti-discrimination wisely looked, it was a good example of what we hope will happen in the future. And that is noticing that some conflicts are likely to arise. People have different beliefs about marriage and family, and so we want to ensure that they're protected at the same time as we're protecting people in their, in housing and employment. So there were specific exemptions written into the bill to allow for both of the groups who might be affected by this bill to be protected. Having said that, so that's the ideal. We see the conflict ahead of time, we resolve it, and so it doesn't arise. There's no litigation necessary, all of that. But having said that, then that still leaves all these other situations where maybe something that's unanticipated, a religious belief that's unfamiliar to us that comes forward, and they also deserve protection. We just want to ensure that they also get a hearing in this situation. So yeah, absolutely. We want to have a foundation of being respectful of religious freedom at the outset, but knowing that we won't catch everything, we won't know that every time that a conflict may arise. We want to also ensure that there's a backstop to protect people in those circumstances as well.
So there has been some criticism of this bill here in Utah. I want to play a clip from one of the legislative committees. So again, it's Senate Bill 150, SB 150, Exercise of Religion Amendments, that as of this recording is moving its way through the legislative process. And on January 29th, it had a committee hearing in the Senate Economic Development and Workforce Services Committee. So for our audience, we're going to play a clip. And Bill, I want you to listen to some of the critiques or concerns that are raised by this person giving testimony to the legislature, and then we'll get your reaction to those. What's the right way to respond to some of those questions and criticisms, and how can our listeners then essentially turn that into talking points that they can use as they say, well, I support religious freedom. Here's why those concerns are maybe unwarranted, or how to address them. So let's watch the clip, and then let's go through that and equip our listeners with those thoughts.
My name is Ellie Menlove, and I'm Policy Counsel at the ACLU of Utah. And I appreciate the opportunity to read our statement on the bill as well. We support the efforts of the sponsor to protect the right to religious exercise of all Utahns, but we're concerned that this RFRA bill may have inadvertent consequences and result in discrimination against third parties and curtailment of others' rights. In practice, the law could allow individuals to claim their religious beliefs, give them the right to ignore laws including non-discrimination, child abuse, and domestic violence laws. We worry about the unintended consequences that the bill may have if passed. For example, the bill may allow a police officer to cite his religious beliefs when refusing to defend a synagogue or a mosque, or a man could claim domestic violence laws don't apply to him if his religious beliefs teach that a husband can discipline his family or his wife in any way he sees fit. The bill could also permit individuals to argue that their religious beliefs don't align with laws that prohibit discrimination. A landlord could refuse to rent to a same-sex couple or a single mother or an unmarried couple, or a guidance counselor could refuse to counsel a student that's gay or trans due to the counselor's religious beliefs. Finally, the bill is bound to lead to costly religious exemption lawsuits, whether meritless or not, that challenge laws and government action that someone sees as conflicting with their religious beliefs. These lawsuits would add additional stress to our already overburdened court system and at the expense of taxpayer dollars. So we absolutely recognize the good intent of the bill sponsor. We have to oppose any bill that would put an individual's religious belief ahead of the common good. Thank you for your time.
So, Bill, following on that clip, what strikes you about those arguments? Where do you think those arguments fall flat or maybe have some misconceptions? What's the right response to some of those concerns?
Well, I first want to say I'm sure it comes from a place of sincere concern that, if you hear the bill characterized as sometimes is as saying that, the religious people get kind of a get out of jail free card every time there's a law they don't like. Of course, it would raise those concerns, but the bill doesn't say just that. So I guess there may be three things. If someone came to me and said, I'm concerned about this, saying something similar, I think there's three things I would say. First is the bill already recognizes there will be times when someone may make a claim to do something that really shouldn't be allowed. And even if they claim for a religious belief for that, I mean, they take a kind of maybe a silly example. If someone says, well, my belief is human sacrifice. We're not going to allow that to happen because, again, the government is allowed under the terms of the bill to advance a compelling government interest, the protection of the life and safety of third parties from someone, regardless of their motivation, religious or not, is definitely compelling interest. The right of people to be free from discrimination is a compelling interest. There are a number of different factors. So most of those situations wouldn't arise. I think the second thing to think about is that it's true that someone may make that claim, and that happens all the time, but that's true with every law. We want to protect people who want to defend themselves, but we don't say, well, you can't claim self-defense, because you might make a false claim. We listen to the claim. We say, well, that's justified or not justified under the law, and then we act that way. That way, someone who is sincerely acting in an appropriate way and needs protection gets it, and then we can. The courts are very capable of handling that. I think maybe the most important thing, the third comment, is that again, this law has this way of approaching religious freedom has been around for decades now. And a lot of the concerns that have been raised about what the bill might do haven't really materialized. And so I'll say that even more strongly, have not materialized at all. And so those particular concerns, I don't think are anything we need to worry about. At a national level, we've been doing this since the early 1990s, really since the 60s in terms of court decisions. And there hasn't been I don't think that our courts have been overwhelmed. I know that no one has gotten away with harming their children or harming someone else and claiming a religious right to do that. And so I think I would sincerely say, well, we appreciate that concern, but the bill does a little more than that, and I think it responds to all the concerns that people have.
Just to put a fine point on that, I think to your analogy of that this isn't a get out of jail free card. You can't say, well, I can do anything I want now as long as I say it's based on a religious belief. That this isn't going to be something that if somebody makes that claim that, the legislative branch, the judicial branch, law enforcement, everyone says, well, we have a RFRA, so they can do what they want. Really, this is intended to be used as a guideline for courts. And so if somebody says, I have a religious right to do this thing, and then there's a conflict that presumably would trigger a lawsuit, the courts would then look at all the evidence and then look at this law that now would be on the books to say, okay, this is the standard that the state of Utah has set. This is the thing that we need to weigh. Isn't that an important distinction, that it's not just a blanket anything goes? We're just essentially asking the judicial branch to be more judicious, I guess, in how they're applying these laws to create the right balance between religious freedom and these other things in society.
Yeah, that's right. And again, if many times there won't be conflicts arise under this law because the law is relatively clear, and I think that most agencies and governments in Utah will try to avoid creating burdens on religious freedom. But if they do, then the person comes and says, well, look, you've created an undue burden. And a court will say, well, is the burden really undue? I mean, maybe it's not that big a deal. That could be a way for them to resolve that. If these exact kind of situations arise where someone says, well, I did this inappropriate harm to someone else, but I should be exempt because of religious freedom, then the government says, no, this is our core. Our core function as government is to protect the rights of others. That's why we have this law. And the court will say, yeah, good point. And you've done that as carefully as possible to protect other people while still allowing religious freedom to the greatest degree possible. There's no violation of the law here. And so the government is still able to protect third parties without any diminution of that. But at the same time, in many cases, religious freedom will be enhanced by the law, which I think is a positive result.
There's one thing that's related that I think broadens the discussion a little bit, and it's something I asked a version of this to Senator Weiler in the previous segment, but for any folks out there who might be wondering, why do we really need more religious freedom protection from the standpoint of, and the way I described it earlier is, no one's stopping me from going to church, no one's kicking on my door saying I can't pray with my family, any of these kinds of things, but that's kind of a myopic view of religious freedom, that yes, those and other things like that are manifestations of practice and belief of religion, but religious freedom is also about the way those closely held beliefs influence how you live your life, how you serve your fellow man. So maybe, I guess, just give us what's the right definition of religious freedom that encompasses these other forms of practice that laws like a Religious Freedom Restoration Act are designed to protect.
Well, one thing I like about this bill is that even though it's based on the Religious Freedom Restoration Act, there's a slightly different title, and it's religious exercise. And I love that because it ties it right to the language and the aspiration in the First Amendment. What we're trying to protect is not the ability of people to sort of go away and slink away into church and have their beliefs, and we can all think less of them because of that. Religion is one of the many valuable parts of a pluralistic society. People who act according to their beliefs are benefiting everybody. And so their ability not only to have beliefs that they have to hide away, but beliefs they actually act on, that's what the First Amendment was intended to protect. And so I think the bill gets at it right. We want to protect people's ability to act on their beliefs. And if we do that, then we've protected religious freedom. Religious freedom is not just a right to worship and, sort of in private or whatever, but the right to just to have something that's so critical to you be something you can act on freely in the public square, just like others who have non-religious but important aspects of their own identity that they want to act on. I think that's what I think this bill is a good way of expressing that aspiration that we have for true religious freedom.
It reminds me of a previous episode that some of our listeners may recall. We interviewed Eboo Patel, who's the founder and president of Interfaith America, and it's a theme that he dug into in a very robust way, that America is a pluralistic society, and we need to not just tolerate, but welcome a diversity of religious views and beliefs and allow those to actually be practiced in our society. And of course, with some of the safeguards you mentioned, that it's not an anything goes. Sometimes there are some balances, but that the spirit of we want to protect the belief, the worship, and also the exercise, because that's how we have a healthy pluralistic society.
Right. And I guess I would add, just based on your earlier question, that kind of protection ends up being really valuable, not only to people of faith, but to others who also want to act on their strongly held beliefs. But at a given moment, yeah, maybe things are going really well, but all it takes is a little crisis or maybe some misunderstandings or other things, and then people's religious beliefs are threatened, and maybe even their ability to go to synagogue is threatened, or during the pandemic where you had maybe restrictions on worship that were more harsh than they were on businesses. These kinds of things do arise, and so even those things that we think of as being highly protected can again be brought into question. These kinds of laws would allow for that situation to be addressed quickly with great clarity for how the court should handle it, and give us confidence that we're going to be protected in the constitutional rights that we were intended to have. So.
As we wrap up, just last two quick questions. If you were to encapsulate all of this into kind of one key message that our listeners can use to articulate, here's why Utah needs a Religious Freedom Restoration Act, what's that core message?
I think the core message would be it's wise for the government to specify that religious freedom should be, or religious practice should be protected, unless it harms the life, safety, health of others. And to the degree we make that clear, we create, we avoid conflicts, and we allow for the easy, simple, hopefully less expensive resolution of conflicts when they do arise.
And final question, if this does pass and it's signed into law, what's next for religious freedom? What other things should champions of religious freedom and religious exercise be looking at in this space?
Well, there are a couple of issues that are still going to be, even with the Religious Freedom Restoration Act in one state, there'll be other states that, where maybe they haven't fully embraced this robust protection of religious freedom. And of course, there will be these cases that come up from time to time where maybe we didn't see them coming, but we need to address a specific concern. I think the other thing is that we still having a backstop is not a good reason to avoid doing the hard work and critical work of avoiding even those conflicts where they arise. To the degree we're not having a lot of court cases over, religious practice, that's probably a good sign that we've done things the best way possible. So I think we want to just continue to be proactive, to notice ways that we can avoid conflicts, and ensure that everybody, religious and non-religious, is protected under our laws.
Well, Bill, we want to thank you for joining us once again on Defending Ideas. It's always great to hear from your expertise and expand the issue a little bit in a way that our listeners can then use these messages in their conversations with folks as they see these issues, and in this case, this bill, progress through the legislature.
Thanks, Nick. I appreciate your time.
Well, we have one more quick break before we leave you with some final talking points. This is Defending Ideas. We'll be right back.
Sometimes it's hard to keep up with the latest policy debate that affects your life. The solution? Subscribe to Sutherland Institute's weekly newsletter, where you'll find in-depth insights from seasoned policy experts, compelling multimedia, and advance notice of special events. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. Before we go, there's just a few key things that stood out to me from our conversations with Bill Duncan and Senator Todd Weiler, and I captured some notes that I think we can use to help essentially become our talking points. So the message that we articulate when we're talking with folks about issues like religious freedom can be grounded on solid principle and some of the expertise we heard from today. So the first point is that religious freedom is about more than just belief. It's not just praying and worship and going to church and those kinds of things. The First Amendment protects your right to live your faith, which means exercising your religion, which means it's going to manifest itself in public life in different ways, and that's actually a good thing for society. The First Amendment protects this right in a way that's significant. The second point is that a Religious Freedom Restoration Act, especially Utah's version that's being considered now, gives protection to this right in a way that appropriately balances with other important considerations of the public good. In particular, as Bill mentioned, things like life, health, safety of other people. And the third key takeaway that I captured from the conversation is that Religious Freedom Restoration Acts are not a new concept. They've been around for many years. It's a longstanding principle that's been on the books at the federal level and also many other states. So it's not something that's new, and a lot of the concerns that some folks have articulated, as Bill mentioned, have not really manifested at all in these other places where these laws are on the books. I think if we remember those three takeaways of the importance of religious freedom, what this law actually does and protects, and why there's actually a benefit to people being able to not just believe, but to live their faith in our society today, there's a real benefit for all of us when it comes to our constitutional rights and the good of our communities, our state, and our nation. Well, that's it for this episode. We hope you have enjoyed this discussion on Defending Ideas and that you feel better equipped to defend some of the principles we talked about today. If you liked what you heard, please visit defendingideas.org. You can subscribe to this podcast on Apple, Google, Spotify, any of the major platforms. Wherever you like to get your shows, just search for Defending Ideas and click that subscribe button. You can also watch on YouTube and also find short clips from this conversation and previous episodes that you can use in your conversations with friends and family and that you can share on social media as you engage constructively and respectfully on issues like religious freedom. That is it for this episode. Thanks so much for joining us on Defending Ideas. From the Sutherland Institute in Salt Lake City, I'm Nic Dunn. We'll see you next time.